It's Michael Linky here. I'm the General Manager at the Institute, so welcome everybody. I just wanted to say this is our second lean-in session for the week, and our first session for the week and our second lean-in. And what these are designed to do is just to bring all of our members together in a very casual environment, just over a spot of lunch hopefully, and just to share our experiences during this time. So as Scott has intimated, Scott Alden joins us. We're very fortunate to have him with us. He's the lead construction projects and procurement partner at Holding Redlich, and Victoria Gordon's also joining us. She's an associate at Holding Redlich as well. So they're going to be discussing the current pandemic and the impact it can have on commercial contracts and operations. And this is including that term that we're all starting to get very quickly au fait with, the term force majeure. So we'll be looking at contract frustration, cost cutting, the workforce, and other rights under contracts, such as suspension, variation, termination. This session will go for about 30 minutes.
Can I interrupt you? Looks like my meeting started. Can I ring you in about an hour or so just to say hi, or you heading out to work?
I'm not sure that was meant for me, but what we can do is
just muted himself.
Yeah, if we can just kindly mute ourselves. Every sniff, every cough is being recorded on camera. So if we can just ask for those of you who are on this call just to kindly mute yourselves and make all the noise you like. But so Scott, I can confirm we can see your presentation live and ready to go, and it's over to you. So everybody, please welcome Scott.
Okay, thank you very much, and welcome everybody. It's a whole new time for me, and obviously for all of us. And I don't think I'm certainly haven't given so many webinars in my whole career as I have in the last couple of weeks, I don't think, nor have I had so many video conference meetings, and nor have I looked at so many force majeure clauses again as I have in the last couple of weeks. So interesting times make for interesting things that come along, and that's all quite exciting and different for us, which is fun. Now, what we're going to be presenting on today is basically the impact on commercial contracts that come up as a result of a situation like the coronavirus or COVID-19, and certain things that come straight to the top of the list, and then other things that people might look to do. And there's also a couple of slides towards the end on what you might do with workforce, for example, if you're in an organisation and with workers and employees and things like that. Obviously, that becomes an issue, and that is coupled with obviously some government measures on bailouts and other things which might make people's choices different to what they might otherwise have been, and things are evolving so quickly, and the law is changing on all of this so quickly as well. We're still waiting to see the final position, for example, on leases, tenants and landlords, and where that ends up. What we do know is that the government's obviously encouraging people to talk and to reach commercially acceptable agreements, and basically a moratorium on evictions for some months, I think 6 months. But obviously the bank's got to come to the party with that and not enforce loans on landlords if landlords are not going to enforce leases on tenants. So there's a whole sort of chain at play that need to be considered both up and downstream. I think you're invited to ask questions, and they will come up on one screen or another. I'm not sure that they come up on the screen that I've got in front of me, but if there are some that start to come in, maybe the person who receives those, I think it's, sorry, the gentleman from the Institute, can't recall.
Yeah, it's Michael. I'll collate those for you, Scott, and I'll go through them, and then I'll do a bit of a Q&A at the end.
Beautiful, beautiful. Okay, thanks, man. All right, well, in that case then, as I say, we've got myself and Victoria. Victoria's going to also present today, and she'll be presenting on an aspect of this, the common law frustration aspect to this, which we will be addressing as well. So I've just advanced the slide. Mike, if you can confirm that that has gone on. Yep, lovely. So as I say, you know, the contracts that people have in place, obviously times like this create difficulties for people, difficulties in usually things like performance, so their ability to perform. And people then sort of look around and say, well, what can we do about that? And there might be something within the contract, what lawyers would say sort of codified or within the contract, or if not, you might be able to rely on the common law. And there's a common law doctrine that is relevant at times like this, and that is called frustration. And people tend to find contracts frustrating at the best of times, but it does have a very legal meaning and a very specific legal definition, and Victoria is going to take us through what frustration means. So the first thing to do when you're faced with a situation in your contract is to say to yourself, well, have you got a force majeure clause, or is there something in the contract that allows you to pull a trigger, send a notice, or have a conversation and say, you know, we need to do something, whether it's change the price, change the time frame, or suspend performance altogether because performance has become difficult, impossible, or very different to what it was when it first was sort of put in place at the time the contract was struck. So that's where you go looking for a force majeure clause. And I should say as well that there is no implied aspect around force majeure. So if you haven't got a specific reference, definition, and clause in your contract that talks about force majeure, then you can't invoke it, you can't use it, it is not relevant to your contractual relationship at all, and you'll have to go to frustration and see if that provides some help to you. So if you have force majeure, then the first thing to look at is to ask yourself how it's defined. And sometimes it's defined very expansively, as in it tries to take in everything it possibly can. And sometimes it's defined in a much more limited way. And sometimes it's defined by giving a list of a couple of things and saying it is force majeure means something that is outside of the control of the contractor, or perhaps either party, and you'd have to look at that very closely. And then it would say including, and then a list of things. So it might say that, or it might say force majeure means 1, 2, 3, 4, 5. And if it says that, it means 1, 2, 3, 4, 5, then that is all it means. If it says that it is something that is outside of the control of the parties, including a range of ideas and a range of events, for example, then it's events like that that the courts would say would apply as a force majeure. Is that the list of examples is not a closed list, it's an open list, but it is confined or constrained or limited to the types of things that the examples might bring to mind. So that's how that would be looked at. You've got a slide here which takes you through the sorts of things that are people think about when they think about force majeure, and they think about things like wars. Acts of God is the first one, and that's always a kind of interesting concept, and there have been some judgments and cases that have looked at what act of God means, which is pretty interesting. But it's basically obviously not a human act, so an act without basically an intervention by man effectively is what that comes, or woman. So act of God is one thing, and then we've got wars, earthquakes, civil insurrections, volcanoes erupting, and then maybe you'd have something as specific as epidemic, and maybe you'd have something as specific as pandemic, for example. So as I say, one place to go first is to look at what is defined to be in your force majeure clause. So that's step one. And if you don't have in your force majeure clause the thing that you're seeking to the thing that's happened, as in this thing, the COVID or the coronavirus, then it can't be used. If it's not defined within your contract as something which is force majeure. So if it said, for example, force majeure means earthquake, war, terrorism, and civil insurrection, and that is all it said, then this definitely would not be of any help to you. But if it says anything outside of your control, including the things I just listed, then there's an argument to say that an epidemic or pandemic could be put into that list, because the examples that are given are by way of example, to colour the definition, not to constrain it overly, but just to give some examples of the types of thing that we're talking about. The first thing to say then is, well, as I say, what is a force majeure? There's an example, and this is not what you'd find in every contract. This is just an example of a force majeure clause of definition. Force majeure event means, and there's a list of things, and this is a confined list. So if it's not on this list, it's not a force majeure. If this was preceded by, after force majeure event means, and it said any act outside of the contractor's or principal's control, including these things, then it would be a wider list. So that was the point I was making before. And as you can see there, we've got acts of God, war, riot or invasions, national emergencies, government action, including strikes, terrorism, imposition of embargoes, extreme weather events, epidemics, and pandemic. So that obviously the coronavirus would definitely apply. In this case, if we didn't have epidemics and pandemics, then you'd have to say, well, does it apply or doesn't it? And you say, well, maybe, because we've had a national emergency declared, and we've had state and territory emergencies declared, and I think national now as well. Maybe, I can't quite recall exactly, but once we do, definitely covered. And then government action is also covered, and the government has taken a lot of actions here. For example, being very clear about encouraging to stay home, but is that an action or just a statement, for example? But certainly closures of businesses. So where there's been a closure of business because government says you have to close, that is government action bringing about a closure, which would then definitely allow you to rely on definition. So that's the first thing, is the definitional point. So look in the contract and see, one, have you got a force majeure clause? Yes, I do. Okay, good. How have we defined force majeure? Well, we've defined it like that. So the next thing to say then is, well, does that event actually stop me performing the works and services? Because that's what the clause would inevitably say, or they usually do, which is, if a force majeure event prevents a party from performing its obligations, then those obligations that are made impossible by the force majeure event are suspended for the duration of the force majeure event. That's what they would normally say. Now then, whether, for example, a principal who is usually responsible to pay, and let's talk about a contract, construction contract, one that an architect might be administering, or let's talk about an architect's engagement and the services that they would be providing to their client. Can the recipient of those services declare a force majeure event on the basis that the supplier or the contractor can't perform? So they're invoking or triggering a force majeure, not because they themselves can't perform, but because somebody else can. And again, the devil's in the detail, as it always is with law and with legal clauses, as in, if it says that the party claiming the force majeure cannot perform its obligations, then it must be tied to the obligations of the party putting the notice forward. But if it simply says, if a party cannot provide or perform its obligations, then either party can declare a force majeure, and either party can. So again, it needs to be looked at exactly what the clause says. And unfortunately, force majeure clauses have not occupied much time in the negotiations, typically, or much time with the lawyers' minds or the clients' minds, because they're hardly ever used and hardly ever needed, because these sorts of things that we're faced with right now are pretty rare. But right now, it's the first thing and the only thing that people are talking about and needing to get some advice about. But there isn't that much experience in how these things go around, either in Australia or anywhere, because it just doesn't come up all that often. Which makes it interesting for us, obviously, as lawyers. And we've been giving advice after advice to clients, many clients, over the last couple of weeks on exactly this point, as I say. So is the performance made impossible? And the thing to say there is, typically the performance of the supplier is often made impossible by one reason or another. For example, a closure of a business, or because they can't actually work at a site, for example, for whatever reason it is, has to be referable to the force majeure, of course. So the supplier's services are often suspended. But it's very unusual for an obligation to pay to be made impossible by a force majeure event, because all that needs is an internet connection and the ability to transfer money via EFT and a bank open and bank accounts on both ends. So those are often unaffected by the sorts of things that we're talking about. So it needs to be, as I say, a force majeure clause in the contract. The event needs to fall within the definition, and the obligation, the exact specific obligation you want suspended, needs to be made impossible as a result of the force majeure event. And that really is important. And people often make assumptions about that and just say, well, a force majeure event's happened, therefore the contract goes into suspension for the next 3 months. Well, that isn't the case necessarily. So those pictures there bring that out, as in people supplying, for example, people constructing on a construction site, engineers doing their works activities, or architects under a subcontract or a direct contract with the client. and then the obligation. Okay, next. Process regarding exercising the rights. So once you've satisfied yourself that the definition is covered, so your event is covered, and also the impossibility of the performance is also covered, then you've got to look to the clause and say, well, what do I have to do here? How do I trigger this? How do I invoke this right? How do I get this contract suspended? Because the sooner it's suspended, the better, because I can't perform. And again, you've got to look to the clause, and it will say a party may basically declare a force majeure event to the other party, and it would usually require that to be done promptly. And so again, you know, how long is a piece of string, all that fabulous stuff, and what does promptly mean? All these things need to be defined or considered in view of, you know, the facts and circumstances, etc., etc. So it's never as simple as to say, well, it's got to be done within 5 days, 7 days, 10 days. But obviously, if you wait a month or two, then you'd be out of time. But if you waited a day or two, then you wouldn't be, because you've got to just have an assessment and see the impact and work it out and get some advice. And so promptly is just the sort of everyday meaning of promptly. So we should all understand what that is. But there's usually needs to be done within that time promptly, and then by way of a notice. So you'd look to the notice clause and say, well, what does the notice look like? How do I send it? Who do I send it to? Is it to be a letter, a fax? Can it be an email? Can I use Aconex or another sort of third-party piece of software in terms of information management, which I know is very popular and common on construction sites and so on? Is that actually a valid form of service? Because if the notice is not properly served under the contract, then arguably you haven't exercised the right properly, and you've got to go all the way back to the beginning and start again and resend the notice to the proper place in the proper form. And then you say, well, what if I missed the boat? What if I didn't send the notice promptly about a force majeure event? Is that in itself a breach of contract? Because it says if a force majeure event arises, then the party affected must notify the other party promptly. So if I fail to do that, is that a breach all on its own? Or is the sanction that I've lost the right to invoke it because I've waited too long and the clause required me to do it promptly? So what if I don't do it promptly? What does that lead to? And again, it depends on what the contract says about that. It may be as specific as to say, if you don't serve the notice promptly, then you lose the right to do it. Or it might well be some kind of soft breach, so not one that would entitle a party to damages or termination necessarily, but one that might water down the rights you might otherwise have been able to rely on. So that kind of thing. Again, look at the clause and see what it says. What does it do to the contract? Typically, it suspends it for the period of time whilst the force majeure event prevails. And that can be a month, it could be 2 weeks, it could be 3 months, it could be 6 months, it could be a year, and who's to say when it ends as well. And that's one of the things that people are thinking about at the moment is, you know, when does this end? Is it when someone comes up with a cure? Is it when the government says everything's fine again and we can all travel again internationally? Or, you know, what does the ending look like? In this context, it would be when the parties can start performing again, obviously. So that's what that would be. So when the force majeure event stops having the effect on the contract that prevented the party relying on it from performing. So once they're able to start performing again, then that's for the contract's sake. And then what happens? Well, it all goes back on foot again. So it's just frozen in time. There are clauses around that say that if it goes on for too long, as in if the force majeure endures for 30 days or 45 days or whatever the period is in the contract, then either party has the right to terminate, because you don't want contracts just languishing around for months on end with the uncertainty of, well, when's this ever going to come up again? Is it ever going to come up again? And let's just kill it now and come back together when this is over and renegotiate and start again then, rather than just have this thing hanging over us with an uncertain time period. So some clauses have that in it. If they don't, then they don't. And that means that it will just be suspended right up until the time that it's ended if it doesn't have that kind of a time clock in there. Okay. That's everything that I'm meaning to say on force majeure for the moment. I expect there might be some questions and we might come to those at the end, Mike, and that's fine. I might just then go to Victoria who is going to take us through frustration, and Victoria is going to signal to me verbally when to move on with the slides rather than unsharing and resharing screens. So Victoria, over to you.
Thanks, Scott. So the doctrine of frustration can apply where we don't have a force majeure clause in a contract. So when there's no force majeure clause in a contract, or where the event doesn't fall within the particular definition of the force majeure event, the common law doctrine of frustration can, in extreme cases, be relied upon. So as a common law doctrine, frustration can apply whether, regardless of whether the contract expressly provides for it. The doctrine is quite an old doctrine. It was established in England in 1863, and to recognise that there should be an automatic mutual discharge of a contract where performance becomes impossible, with neither party being at fault and the obligations under the contract being radically different from those contemplated by the parties to the contract. So from the outset, frustration isn't easy to establish, as it does require those elements: the impossibility of a contract performance, all the obligations under the contract being so fundamentally or radically changed by an unforeseen event from what was originally contemplated by the parties. Performance of a contract becoming more expensive or onerous, even though caused by no fault of the parties, will generally not be enough to establish the doctrine. So some examples of frustration include physical destruction of the subject matter of the contract, a change in law rendering performance illegal, restraint by an injunction, non-occurrence of an event which formed the basis of the contract, or an outbreak of war and possibly an outbreak of a pandemic. It generally won't be found in situations where there's just a mere delay, so a construction delay or a shortage of materials, a supervening event that was contemplated by the parties, even if the parties failed to anticipate the severity of that event, or whether it's just hardship, inconvenience, or simply a bad bargain. So the question of whether COVID-19 would qualify as a frustrating event, probably. It would depend though on its impact on the particular contract and whether it rendered it impossible to perform rather than just more difficult. And it would also depend on whether pandemics are already captured by a force majeure event under the particular contract. And that's because force majeure is said to be a codification of the doctrine of frustration. So this raises an interesting question. If a party does exercise a contractual right of force majeure, is that party then subsequently, Scott, we're just still back on that. Yeah, perfect, that one. Can that party then still rely on the doctrine of frustration to terminate the contract at a later stage? So effectively, can you rely on both principles? So this is really important where the contract does include a force majeure clause, but doesn't allow for termination for an extended force majeure event. So in this situation, an express force majeure clause will preclude the operation of the common law doctrine of frustration if that clause is sufficiently wide enough to deal with all of the specific frustrating events in question. Ultimately, again, as Scott just mentioned, it would depend on the scope of the force majeure clause and the construction of that particular definition. So if it's drafted so broadly to include all the circumstances where a party cannot perform its contractual obligations due to events beyond its control, then there will be limited scope for frustration to operate. In contrast, where a force majeure clause is drafted narrowly, for example, it doesn't include pandemic, then the doctrine may still operate where those events occur. Also, if the force majeure clause includes suspension as a remedy, but did not include termination after an extended period of time, then in that circumstance, it would be open for the courts to find that the relevant contract is frustrated if it became impossible to perform because of COVID-19. But because the doctrine of frustration can result in quite harsh consequences, which I'll come to in a minute, most parties prefer to include a really wide definition of force majeure event in the contract, which will effectively avoid the doctrine of frustration and instead allow the parties to govern the effect of the particular event under that contract. So next slide, please, Scott. Thanks. So So what do you need to establish frustration? Just to recap, the elements for it to be established are an event that is no fault of the parties, that makes the contract impossible to perform, or the nature of its performance so radically changed since what was agreed by the parties. So merely making performance more difficult or costly will be usually insufficient. Next slide, please, Scott. So when a court considers a case of frustration, these are the key questions that will be considered, and this is established in the High Court case of Cadelpha. So 4 key questions that the court will look at. 1, what was the substance of the contract, being the assumption or condition or state of things, which is necessary for the fulfilment of the contract. So the essence of the contract that the parties agreed to at the beginning. What was that condition or state of things then prevented by the supervening event? Was the event which prevented performance of the contract of such a character that it cannot reasonably be said to have been in contemplation of the parties? And was the change so unexpected that if performed, the contract would be radically different from what was contracted at the beginning? So they're the 4 key questions that a court will consider when looking at a case of frustration. Next slide, please, Scott. So the remedies and losses if frustration is established. The legal consequence is that the contract will be automatically terminated at the point of frustration. So it won't be terminated from the beginning or execution date of the contract, and it's only future obligations from the date of termination that are discharged. This means that after the point of frustration, neither party can demand future performance from the other. So it's really important to understand that termination is the only remedy available, and the courts aren't able to vary or suspend the contract in question. However, at common law, prior obligations can still be enforced. So if there's any payment of outstanding money that was owed prior to the date of frustration, damages for that amount can still be available, but only for events that occurred prior to the event of frustration and termination. Also, terms in the contract that are clearly intended to be operative after termination may still be enforceable. So common clauses that we see like this are dispute resolution clauses or confidentiality obligations, which are usually drafted to bind the parties after the date of termination. If a contract is terminated because of frustration, then losses will usually lie where they fall, and this can result in harsh outcomes for all parties, even with the benefit of legislation in some states that's been put in place aimed to address this harshness. So an easy example is where a venue hire deposit has been paid for an event, but the event subsequently burns down the day before. So under the common law here, the contract will have been frustrated and all obligations from the point of frustration will cease for both sides. In that example, the losses will lie where they fall, meaning that the deposit would have been forfeited. Another way to deal with this harshness apart from the effect of legislation is to include in the contract how costs and losses will be apportioned if a contract is found to be frustrated. And just the next slide, please, Scott. So the effective statute, as I've mentioned, there's some state legislation that's been put in place which aims to reduce this harshness of where the losses lie. In Australia, there's only 3 jurisdictions that have enacted this legislation: New South Wales, Victoria, and South Australia. Each statute operates slightly differently. However, the overarching aim of each is the same, which is to provide a more fair result, a more fair and equitable result. Under these acts, the courts also have wide discretionary powers to make just and equitable orders in a number of contractual situations, but there are a number of contracts that are excluded from the operation of the acts, including contracts of insurance. So just some key frustration takeaways before I hand back over to Scott. Frustration occurs when an event occurs that is due to no fault of the parties that makes performance of the contract impossible, or the obligations under the contract being so radically different from those contemplated by the parties to the contract. It's generally quite difficult to establish, and mere hardship won't be enough. Losses at the time of termination lie where they fall, which can result in quite harsh outcomes. And because of this harshness, most parties attempt to avoid the doctrine by including an all-encompassing or really wide definition of force majeure clause in the contract. Back over to you, Scott.
Okay, so that's the position with contractual force majeure and common law frustration, which in some states the frustration aspect is supported by some statutory intervention, just to try and put back a bit of fairness in the outcome, which is otherwise a pretty harsh event, as we've heard. So we've just gone through those aspects. I'm now just going to touch briefly on some other contractual clauses and mechanisms that might come up here where you haven't got a force majeure clause, for example, but the contract might help you elsewhere. So, for example, you might have a right to suspend the contract anyway. So a principal will often have a unilateral right to suspend if it wants to. It might be a bilateral. It might be something that needs to be done by agreement. So it could be either party unilaterally, might be both parties, but by agreement only. Again, we'd have to see what the clause says. A lot of construction contracts do contain the right of the superintendent and the principal to suspend at their discretion effectively at any time, but it is usually a qualifying cause of delay and a compensable cause as those Australian standards define them, which means the contractor would get both time and the cost implications of that suspension. But that might be the only way to deal with it or the most fair way to deal with it. So that's something you can look at. Again, do we need to give notice? Probably. Are there time limits and time bars on the right to do that? A unilateral right for the principal? Not usually. The cost implications I've covered, which is the principal in that example would typically pay the delay damages associated with that. If the contract has got a $0 delay damages, which some do, then it will be $0 for that delay. So again, depends on what the contract says. And again, just because the contract says that doesn't mean you can't do something else. You can agree, negotiate, vary, whatever, outside of the current terms of the contract, because the contract never sort of thought about this and parties want to be fair and get out of it the most fair and best way they can. I'll come back to that at the end. The other thing is, does this give rise to an EOT? An extension of time claim? Is it a qualifying cause of delay that the contractor might be able to rely on so that the clock doesn't keep ticking, the program does not keep going on whilst the work is suspended or delayed or impacted by the force majeure, by the pandemic, by whatever it might be. And that can be caused, or they can give rise to, for example, delays in supplies coming in, site closures, working together limitations, working hour limitations. Lockdowns obviously is a whole different thing again. So does it give rise to a qualifying cause of delay? Again, what does the contract say? The Australian standards, standard form construction contracts, this typically would be an extension of time. But really, if you're a contractor and we're dealing with this, an EOT really isn't necessarily the thing that you want. You might want instead to do something the way that a force majeure might have it, which is just to suspend whilst this is blows over. But of course, the contractor, if they're able to, may want to keep working. And that's certainly what the Australian government response has been so far, is to keep construction sites and other businesses working as best they can. Hence, we're not going into lockdown just yet, but are heavily encouraged to not move around and stay at home as much as possible. So that's the sort of balance we're dealing with, and the contract will play out differently depending on what we're doing. What about a variation? Does this give rise to a variation of contract because the contract has varied in some way? So can the contractor say that what they bargained for, the work they're doing and so on has changed, and therefore there's a variation that they can claim for? Again, you'd have to see what risk the contractor's taken on, what is included in their scope of work specification and in the definition of works and services, and whether or not this and what this brings about qualifies as a variation. In any event, it might be something that the parties want to deal with by way of variation. So, for example, there's no reason why you couldn't import into an Australian standard a force majeure arrangement now, even though it doesn't have one to begin with. And no Australian standard construction contract has actually got force majeure in it, none of them. They deal with it by way of EOT variation and other things, but not force majeure. That's not to say, as I say, that people can't vary contracts as they want to. So you could bring that in now so that that outcome is achieved in the environment that we now find ourselves, and that might be best for everyone. So never lose sight of the fact that you can change a contract, change the deal, change anything by variation, no matter what the contract says. It might be that you need to do a deed of variation, and I won't get into the whys and wherefores of that too much right now, because that's not what we're here to discuss. But if it is just something that you're agreeing for convenience with no additional work, no additional pay, no obligation in exchange for a benefit, then you'll need to do it by way of a deed. So a change like that, you'd need to express and agree as a deed. Okay. You can terminate, potentially a principal can terminate for convenience. And they might do that if the alternative, which might be a non-force majeure obligation to keep paying for services you can't get, for example, or whatever it might be, you might want to look at whether there are any termination rights in the contract. Termination for convenience being the most likely candidate, which you find in most government contracts. I haven't seen or had any clients, and we've dealt with a lot of clients in the last couple of weeks, as I say, no one has looked to this just yet. People have asked if we can terminate for past bad performance, which I'll come to in a moment. That's a different thing. No one's looking necessarily to terminate for convenience, but it certainly is one of the options that you'd have to throw up at this time. You might be able to terminate for breach, although it's unlikely, because usually there's a show cause procedure where you need to send a notice to a contractor and advise them of the breach they've committed, give them a chance to remedy that breach, and then life goes on, or if they don't, then terminate. And I'd expect that if you were to send a show cause notice to a contractor now, then you'd be met with either a force majeure notice in return, which would just suspend the contract if there's a right to do that, or a frustration claim, which would terminate, and then a frustration rather than a termination for breach. It would terminate for frustration. So I think that would be a pretty interesting move, and I think whichever way you would turn, that would not produce the outcome that any party would really want in the current situation. So I would be advising against this. So that's the contract and the various levers in the contract other than force majeure that you might look to if there is no force majeure. I had a lot of clients obviously asking us in the last couple of weeks about workplace relations. Now we have a dedicated workplace relations team here. I'm in the constructions procurement group, but I've worked closely with the workplace relations team on some options with some clients that I've been talking to. So I'm just going to put those out there, but as I say, that's not my specialty. If you do have questions or issues very specific about this area, then we might need to take them on notice. So options around workplace relations, just so the business can keep going. And again, this needs to be viewed through the prism of the government bailouts that are being announced, by the hour. And that will certainly help with a lot of this. And what you do may impact your ability to claim some of those bailout payments too. So it's you want to go and get some advice around that from your accountant, from your legal advisor, or whoever before you take any knee-jerk reaction. Like that. So various things you might be able to do. Some things that our clients have done is one is stand down. Standing down is difficult. There's a specific provisions in the Fair Work Act around it, and it only applies basically where the business cannot continue to trade. So Qantas International arm of Qantas, fine. Obviously, that's a stand down. Pubs, restaurants, and so on, casinos, all those places, and takeaway places. Takeaway can continue, but anything like that, businesses like that, nail bars, all those things that the government said must close, you can definitely stand down. And what that does is the employee keeps their job, their annual leave and superannuation and other entitlements continue to accrue. They can't claim redundancy, obviously, because they're stood down and they're still on the books, but they're not getting paid. So that's how that looks. You can then ask employees to take leave without pay. So if you haven't got a right to stand down, then you might say, look, we don't want to make you redundant and we don't want us to fire you for other reasons. What we'd rather do is for you to agree leave without pay. And so you come back to this job, but we just can't pay you at the moment because we are not getting the revenue that we were getting. So that's a discussion that can be had with the employee, but you can't force that. If the employee says no, then it will have to either be a redundancy or a valid term, unless there's been specific laws in relation to COVID response, which allow you to do something else. And there have been a couple, but they're pretty unique and industry specific, so I won't go into the detail. So leave without pay is that by negotiation can't be forced, but it might be a good option for an employee and an employer, where the employee wants to keep their job at the end of this and the employer wants to keep that person rather than have to go around recruiting someone who may as useful to them. You can ask an employee to perhaps accept a reduction in pay, again, by agreement. So you could say, look, we've just got to get through this, and so we're asking everyone to take a X% pay cut. That's not without precedent. People do that. But of course, you mustn't go below any relevant modern award payments, a minimum payment, because if you do, then obviously it's illegal. You have to pay penalties and catch-ups, and also you might face the ire of press, as we've seen with some businesses in recent times. You then might be able to force people to take leave. So that's an option. It's like, well, you've got a lot of leave accrued, and now's a good time to take it. But of course, they can't go anywhere, so they don't necessarily want to take it. So that can be a difficult conversation to have. But again, it's all just about trying to keep the business going. You might invite people to move from full-time to part-time. And again, just make their full-time position effectively redundant and move them to part-time is a conversation to have. Just by way of trying to get through this. So from full-time to point 8 is 4 day a week, 0.6, 3 day a week, that kind of thing. I've mentioned redundancy a couple of times. Where a job is redundant, you can trigger redundancy at any time, provided that's a valid redundancy. Now, obviously, there would be good arguments that certain positions are redundant because there might be a superfluous personnel in the team, or people without things to do, and so that's a fairly easy argument to make. You need to be somewhat careful to make sure it is genuine. You can't sort of make someone redundant and then employ somebody else in that position next week whilst this pandemic continues. That would obviously not be a valid and appropriate thing to do. But this will give rise, no doubt, to positions and people that are genuinely redundant and need to be dealt with in a way. And there are statutory redundancy payments that flow. Termination for performance, yes, that can still continue. Termination within probation periods of 6, 12, 3 months, depending on what you agreed and what's in the legislation and so on. Again, that can be triggered. So those things are basically options. So that's the sort of legal stuff. There's a few opportunities for architects and people in the construction sector. Classic one is sort of getting a fit out done or a refurbishment. So your pub's closed, your restaurant's closed, and there's no people in there enjoying meals, etc. Then, provided you've got the balance sheet to pay for it, then it'll be the least disruptive time you'll ever have to do a fit out or to do a refurb or something like that. So if the money's there to do a refurb and a fit out, and construction workers can still work, which at the moment they can, then this is the sort of low-hanging fruit things that people might be encouraged to go and do, and you might have conversations with your client about that. Also a time you can have a look at internal processes and procedures and things like that, and just sort of clean up in-house stuff. That's what we're doing. Obviously, lawyers are fairly busy with this issue, but generally people aren't going out doing non-essential legal advice. So every industry is going to be down, including the legal industry. And so what we'll do, we'll spend time marketing and doing presentations and informing clients and lifting our brand at the same time as dusting off precedents and just making ourselves, as fit and ready for the recovery as we can be, which is really what I think a lot of businesses can also focus on. Okay, I think I'll finish there, Mike. If I don't know whether we've had any questions pop in, or if people want to sort of ask them now, they can.
Yeah, sure. Thank you, Scott. And thank you, Victoria, for that as well. That was fantastic. We have got a number of questions. So some of you have very kindly sent in questions in advance of the presentation. And some have come through on that Zoom group chat as well. So thanks very much to those who have asked questions. So I thought I'd just go through a few of them. The first question comes from Lawrence Greenman. He's Design and Quality Manager at Allen Jack & Cottier. And he said, look, AS 4000 1997 General Conditions of Contract, as well as the ABIC contracts, don't mention a pandemic or any other sort of reasonable facsimile of such an event, nor do they include a catch-all clause where all items outside the control of either party, be it the principal or the contractor, will have time and costs apportioned in this fashion. as a result of this being such an unprecedented event. So his question is, who's best to apportion time here, Scott? Who's best to apportion costs and EOT claims? Is arbitration the best starting point, or can retention money be called up under these circumstances to assist with project liquidity? What's your answer to that one?
Well, you can only work within the confines of the contract. So if the contract doesn't allow you to rely on retention money, for example, or to go to arbitration to argue something, because there's nothing to argue, because it just is what it is, which is that there is no, assuming what's being said is right, so we're dealing with a contract that doesn't have any of those things or any sort of trigger points to trigger an EOT, to trigger delay costs, or to suspend because of FM force majeure, then the contract just goes on. And if the contractor doesn't perform because it's just a little bit harder in the current environment that they're in breach, the only thing that the contractor then or the principal can do if they want to, that doesn't suit them, is to negotiate an alternative arrangement by variation by agreement, as I mentioned, or to look to common law frustration to say, look, it may not be a qualifying cause of delay as we know it, because it's not rain, it's not latent condition, it's not this, it's not that, it's not a third-party supplier, it's not a principal action. So it's none of those things that we typically use and do and what we're used to, but it is something so very much out of nowhere and so fundamentally destructive of the contract that the contract is frankly frustrating. So that's the place to go, and you would definitely have that argument if it was resisted under the dispute resolution clause, because that would still apply, and go to expert determination, arbitration, or litigation, depending on what that contract is.
Okay, thank you, Scott. The next question comes from David Pond on the Zoom group chat, and he said, and this is a very good question and one that we've been asked many times at the Institute in the last few days, any suggestions or guidance for a template or wording on an appropriate force majeure clause in contracts? Not many of us have been exposed to force majeure clauses really in the last few years, but in the last few days, it's really come to light. Any examples or guidance you can give us on an appropriate, nicely worded FM clause?
Well, I suppose at the risk of kind of just verbatim reading one out, which I haven't got one in front of me anyway, or making one up as I go along, which I could probably do, but I'd be disinclined to do. I'll get sued if I forget something. But there are sort of templates around, and there are contracts around. I think the thing to do is, instead of me sort of just reading out for 5 minutes a long-worded force majeure clause, is to look at the components of that clause and then say, well, what do I want in my definition? Who do I want to be able to invoke the right? Whose obligations am I concerned about being suspended? Mine, the contractors, or both? And then if a force majeure clause does in fact suspend those obligations, then what do I want the position to be? A suspension of contract obligations for the term of the force period. So those are basically the steps and the components of the definition. What it prevents you doing, who has the right, how do you enforce the right, and how long does it exist for before it just is all bets are off. And Victoria, I know you've done a lot of research on this as well. If you've got anything to add to that, you're welcome to jump in. I think I can't hear you, V. I don't know if Mike, you can.
No, I can't. Sorry,
Sorry,
Victoria.
can you hear me now?
Yeah, that's great.
Can you hear me now?
Yeah.
Just from a frustration point of view, as I mentioned, so making that definition as wide as possible and using those words like including instead of those definitive words. So it's not just that list, but expanding it as much as possible so that you can exclude the doctrine of frustration if that's what you want to do.
Yeah. Great. Thanks, V.
Thanks, Scott. Thanks, Victoria. Navneet has pulled in a question which is really interesting. He says, look, can the contractor argue on the basis that a pandemic be treated as a latent condition? What's your response to that?
Well, yes, definitely could, depending on the definition of latent condition, site condition, and what's in and what's not in. But there is no reason why a pandemic couldn't be a latent condition in the broadest possible sort of terms of what a latent condition can be, which is a condition of the contract that impacts on the contract that nobody anticipated or was able to foresee at the time of signing the contract. It ticks all those boxes. Often, though, they're confined to environmental, climatic, geotechnical things only, and in that case, I would say absolutely not. But provided there's no such confining of the definition of latent condition, then there's no reason why it couldn't be. Yep.
Okay, thank you. There was a question from Heidi Prong, who's based in New South Wales, and this isn't really a legal question as such, but Heidi assumes that we can only ask our clients to be understanding on site for COVID-related delays during existing ABIC contract periods. What are your thoughts on just, exercising common sense?
Can't hear you, Scott.
I've not done, can you hear me now?
Yeah.
That's better.
Okay, great. We're seeing a lot of this, right? So particularly with landlords. So we do a lot of work with landlords and owners and developers and et cetera, et cetera. But let's take the landlord example. You can be a hard-nosed landlord and demand that leases and rents continue to be paid, for example, or you can say, look, guys, we'll allow you to have some kind of rent relief in the interim, provided there's some sort of opportunity to make that up in the future when times get good again. And there's nothing contractual or legal about that. That's just people being fair and reasonable and just getting through this bad situation as a kind of team and reasonably and fairly as best they can. I think if the contract that you're dealing with does not provide you with any help, then you need to basically look at the same thing, which is to just have adult conversations and be fair and reasonable and do all that you can. What I would say, obviously, if my lawyer's hat on, is whatever agreements you come to, just document them so that they are stuck to and so on. You're on mute as well, Mike.
Yep, no worries, thank you. That's great. There are a couple of other questions, but what we may actually do is I'm just about to hit the send button on there. If you can, everybody can look at the Zoom group chat notes. I've put a direct link in to Scott and Victoria's presentation today. So if you want to click on that link, that will give you access to those PowerPoint slides in a PDF format, and that's sitting on our dedicated COVID-19 response page as well. But I do want to say thank you to Scott and Victoria for joining us today. We're doing these lean-in sessions every couple of days during the week, every Tuesday, every Thursday. So on Thursday, we'll be joined by Melissa from an accounting firm, DFK Everalls in Canberra, and she's going to be talking about business continuity and protecting your architectural practice during this sort of unprecedented time in which we're going through. These recordings, we're recording these sessions, and we'll also be uploading these in due course into a library of all of our membership lean-ins as well during the week. So they'll be up on our COVID-19 response page as well. But that's really it for today's Lunch and Learn session. And thank you very much for joining us. What we will be doing, obviously, if you have any questions, don't forget to email us or get in touch to recommend what you'd like to see in these sessions as well. So good to see everybody. Hang in there, stay safe, stay at home, and we'll catch up with you soon.
Good on you, Mike. Thanks very much.
Cheers. Thanks, guys.
Thank you.